Okay, I believe we're live now. Good afternoon, everyone. My name is Jeremy Herman. I'm an employment lawyer at Samfiru Tumarkin, LLP. It's great to be back. I've done a bunch of these sessions, and I'm happy to be back here to answer your questions. As you know, we host many of these Q&A sessions across our provinces in which we operate in Ontario, British Columbia, and Alberta. And the goal is to educate you. It's to make the audience be familiar with their employment rights and to answer as many questions as we can within this time. So with that said, I'm going to start off with a really important topic. And we're seeing a lot of layoffs now. And there's one company in particular that is engaging in mass layoffs, and that company would be Switch Health. And we're seeing a lot of individuals come through our doors who have been terminated or laid off as a result of the recession, typically that we're in right now, from Switch Health, and they're offered a package that is pretty much what I like to call a one-size-fits-all severance package. It's a package where all employees are being offered the same thing if they're being terminated, and that's a problem. And the reason why that's a problem is because termination entitlements look different for each employee who is terminated. And you'll hear us talk about this in all of our media, and it's critically important that everyone understands it. If you are terminated, what you might be owed could be very different from your colleague. It could be for the same reason that you're terminated from the same organization. But termination entitlements are determined based on your age, your length of service, the position you were in, how much money you earned in that position, and generally the availability of similar work right now in the job market, which we know is in some markets good and some markets bad as a result of the recession. And so don't just accept any package that you're being offered from any organization. You have to ensure that you contact an employment lawyer. We'd love for you to contact us to look at the termination entitlements that you're owed and to assess whether you're being offered the right amounts. So don't just accept anything that comes your way. And you can contact us at help@employmentlawyer.ca and find out more about this at employmentlawyer.ca. Now, just on this point, what we're also seeing, and I touched on this before, are layoffs. So not necessarily terminations, but a layoff, which is where the company is saying, we're going through difficult times. We don't want to let you go completely, but we're going to lay you off for the time being. And you might see in the layoff notices that you're being provided that the company is saying, we'll lay you off either for 13 weeks or for 35 weeks. And that will depend on whether you're receiving benefits during that layoff period. But you have to understand that you can take the position right now, the day that you're being laid off, that the layoff is actually a termination. You don't have to wait to see if you're going to be recalled after 35 weeks or after 13 weeks. You can treat it as a termination right away. And that would be what we call a constructive termination, which is, again, not where your employer is outright terminating you because they're laying you off, but it's where they're changing the terms of your employment fundamentally in such a way that you don't accept those changes. And because you don't accept them, then you can say that is a termination of my employment. It's a constructive termination, and I'm owed full severance pay, which could be up to 24 months of pay. But like I said, we're seeing a lot of these now as well because we're heading into a recession, or some might say we're already in it, and companies aren't sure what to do. So they may not be terminating you, but they might be laying you off. And you have to understand your rights in that case. Now, it's also critically important that we take a look at your employment agreement in a layoff situation. Some employment agreements speak about layoffs and they actually permit them. And if you agree to that and the termination and the provision rather about layoffs is enforceable, you may not be able to argue that the layoff is a termination. Similarly, I just dealt with a case today where an employee was laid off and they were asked to sign a notice that they agree to being laid off. And they did so because they don't understand their rights, which is understandable. You have to, usually listen to these sessions or contact an employment lawyer to understand your rights on these issues. And so they signed the document that says that they agree to be laid off. That's going to be a big problem for that person, because even though they didn't understand their rights, now there's evidence that the employer can point to that said, well, you can't treat the layoff as a termination because you agreed to being laid off. And so critically important that if you're being laid off, you don't sign an agreement that says that you agreed to the layoff. You contact us right away, again, at help@employmentlawyer.ca, and you determine with our help whether you want to treat that layoff as a termination and go for your full severance pay at this point in time right away. Don't wait on that issue. The longer you wait, the more problematic it could become for you. So don't sit on it and contact us. And so with that, we'll open the floor now to questions. So I see a question from YouTube and I apologize if I'm not pronouncing this right, but Oikram or Oistram Emil, and it says, can my work agreement be considered voided by email conversation? I'll be honest, I'm not exactly sure what you mean by that. It depends on what the contents of the email conversation were. But if you have an employment agreement, the agreement is in place. There could be many factors that make the agreement unenforceable or parts of the agreement unenforceable. And you will have heard us talk about this in various media platforms, that there could be termination provisions in that employment agreement that are not enforceable, for example, and those are very important provisions within the agreement. So it really depends on the agreement, and it depends on the conversation you had by email. Perhaps if a conversation by email said, very clearly and unambiguously that whatever employment agreement existed is void, then that would be evidence to point to say that the employment agreement is void. So I hope that answers your question. If you have a follow-up or more information, then feel free to post it in the chat. Okay, and we're going to move on here. We have a bunch of questions rolling in. So the next question is, I was let go from my job as a mechanic after refusing unsafe work. No severance was given, and my employer is refusing to let me come back on site to pick up tools and equipment that are my property. Is there anything I can do about this? Absolutely. First of all, there's a lot in here. One, you absolutely have a right to pick up your property. I don't know what the reason is that your employer is giving you for not being able to come and pick it up. If there's a valid reason for that, then so be it, but they have to come up with a way of providing your property to you. So shipping it to you or whatever they have to do to get it back to you because it's yours. And to go to your earlier part of your question about severance, you are absolutely owed severance if you were let go. There's no question about that. And if you were let go as a result of refusing unsafe work, that also could be a problem according to Ontario legislation called the Occupational Health and Safety Act. That act says that an employee is allowed to refuse unsafe work. And so if you've done that, you've done nothing wrong, and your employer can't let you go as a result, and you might be owed perhaps even more compensation than just your basic severance in that situation. If there was a reason that the employer let you go, and that reason is that you made a complaint about unsafe work. So I hope that answers your question. And again, if you have a follow-up, then please post it in the chat. Okay, so moving on, we have a question from Miranda on YouTube. And Miranda says, what about if your contract has a non-compete clause? Is that something you can get sued for by a previous employer? Great question, Miranda. And we're seeing a lot of evolution in the law right now, actually, with regard to non-compete clauses in particular. So in many cases, non-compete clauses are no longer legal. It's definitely problematic. It depends on the circumstances. So it is very important that we actually review your employment agreement or review the non-compete clause that probably is in your employment agreement to see whether it is drafted in a way that's legal, or based on what employment you're in, it will also be relevant to determine whether it's legal. But given that, if it is an illegal clause, then your employer will not have recourse if you breach the clause, because the clause is not legal anyway. So no, you can get sued, but it doesn't mean your employer has a good case. Your employer can choose to sue you, but they might have a very weak case, and it probably won't go anywhere if the non-compete clause that they're suing you over is illegal in the first place. Okay, looks like we have a follow-up from, and again, I apologize if I don't pronounce your name right, on YouTube from Oikram. And he says, due to recent changes on my employment, I asked for a new contract and was only told that it was voided after insisting I got an answer to my email saying my contract was voided due to the changes. And then you were laid off without notice. So if you were, regardless of whether this employment agreement is void or not void, if you were laid off, if you were terminated, you were entitled to severance. If you're laid off and not actually terminated, as we spoke about earlier, you very well could be entitled to severance pay as well if you treat that layoff as a constructive termination. So what I recommend is that you make an appointment with us, contact us at help@employmentlawyer.ca. Let us review the agreement. Let us review the email correspondence that speaks to whether this employment agreement is void. And if you were given a termination notice or a layoff notice, we need to see that as well. And you very likely are owed full severance pay in this case. So don't hesitate to reach out to us. Okay, so Suzette asks on YouTube, is an employer allowed to force you to use your vacation days before the end of the year? I have holiday left, but was hoping to get paid out, and my employer wants me to take the time off instead. Your employer can't force you to take time off. If you have a certain amount of vacation paid days that you have to receive per year. If you don't take those days, then it could be that they don't accrue next year. That is possible, but you can't be forced to actually take time off. If you're owed vacation time, then you have to be paid that vacation time. So some situations, the basic entitlement is 2 weeks of paid vacation per year, according to our provincial legislation. And then it goes up to 3 weeks, I believe, after 5 years of employment. And so you have to be paid that time. So if you're not paid that time, then that's a problem. It could be a problem that we can resolve through the Ministry of Labor with our help, Suzette. So let us look at this situation more closely. Send us an email, contact us, look online for more resources on this topic at employmentlawyer.ca, and contact us at help@employmentlawyer.ca so we can see what the correspondence is that you're having with your employer. What is the reasoning that they're giving you that they want you to actually take the time off and not pay out the vacation days? And that very well could be a problem. So please don't hesitate to contact us and let us figure this out for you. Okay. We have another question. We have many rolling in, which is great. So we have a question from Layla, and they say, Suzette, no problem. Layla says, I was on a 20-month term contract for a healthcare position, but after 8 weeks, I was told I was doing work outside of my scope, which was not true. Am I owed any severance in this situation? Well, it depends on if you've been terminated. So if the contract has been terminated, then yes, you would be owed possibly severance. In fact, you might actually be owed more. You might actually be owed the amount of time that you were supposed to work, which would be 20 months. If you were let go after 8 weeks, based on what the contract might say, you could be owed for the entire 20-month period. So that potentially would be more than your severance entitlements, in fact. And that's called a fixed term contract from the sounds of it. So it depends on if you were actually let go as a result of the situation or not. If you were just told you're doing work outside of your scope and it was a warning, but your employer didn't let you go, then there's nothing to obtain there. Maybe potentially in the future there might be if they do let you go. But if you were let go as a result of doing work outside of the scope, then you would be owed severance pay or the damages, like I said, for the full 20-month fixed term period that you were supposed to work for this employer. So again, don't hesitate, contact us. Let us take a closer look at what's going on here. And we'd be happy to assist you further. Now, at this time, before we move on with more questions, I want to talk about another situation that's trending now, and that has to do with Twitter. And so we know Elon Musk has taken over Twitter, and he's creating some problems, some might say. And most recently, what he has said is that if employees are not willing to accept what I believe he called a hardcore work environment, then they can resign and receive 3 months of severance pay. So there's a lot of issues with that. First of all, a lot of employees have resigned as a result, hundreds of employees, I believe. But like I said earlier, and I started off the Q&A session with this, there's no one-size-fits-all severance package. So the fact that Elon Musk is offering 3 months might actually be a lot for one employee, and it could be very little severance for another employee. Depends on each employee's circumstances. Depends on how long they work for the company, how old they are, what position they were in, etc. So that one-size-fits-all approach that Elon Musk is offering is just another example of a problematic approach that an employer would take to offering severance pay to employees. So if you're in that situation with Twitter or in a similar situation, make sure that you get the right severance that you're owed, which could be up to 24 months of pay, a full 2 years of pay, depending on those circumstances. So let us know. And it's another great example of something I spoke about in an earlier Q&A session. And that's the concept of quiet firing, which is another way of saying constructive dismissal, really. In the law, it's called a constructive dismissal. So if your employer is creating a situation, in this case, it would be a hardcore work environment that changes the terms of your employment in such a way that is fundamental and substantial, then that could be a termination of your employment right there. So you don't have to be in a situation where you just accept these changes. You can say those changes are substantial and therefore I don't accept them, and I'm treating that as a termination of my employment. So don't accept that hardcore work environment and don't resign, because when you resign, typically you're not owed any severance pay. So do not resign. Don't just accept a one-size-fits-all severance package of 3 months or 1 week or whatever the company might be doing. Make sure that you get the actual amount that you're owed. It's just very important to note that, because like I said, in this recession, it's fairly common that companies are laying people off and terminating people and offering a very specific amount of severance. And lastly, before I go on with more questions, it's a good time to talk about the Pocket Employment Lawyer tool that we have created. And you can find this at pocketemploymentlawyer.ca. And that will give you an idea of how much severance you're owed. So we'll ask you questions about your employment situation, how long you've worked there, if you were terminated, what was the nature of the termination, how much money have you been paid, how much money did you earn as a salary, what position, etc. And then it will spit out for you a very realistic idea of how much severance you should expect in the situation. And this is a free tool. Again, you see it on the screen, pocketemploymentlawyer.ca. Use it, figure out how much severance you might be owed, and then contact us at help@employmentlawyer.ca, and we will help you get that severance pay. So with that, let's jump into more questions. So we have a question from Aaron. What kind of changes is an employer allowed to make to your position? My job has had a number of small changes over time, but if they made them all at once, I wouldn't have agreed. Interesting. So a couple things here. Typical changes that your employer cannot make are changes to your hours, changes to your pay, changes to your work location. These are typical situations that an employer might implement. They might change the nature of your work in one or more of those ways. And that could be a constructive dismissal of your employment. Again, you can treat that as a termination because they've changed substantially the terms of your employment. Now, we'll take an example of a pay cut. So there's no exact percentage that the law has set out that says that is illegal. But typically what we've seen is in the over 10%, certainly over 15% of a pay cut would be illegal. And that you can very easily treat as a constructive dismissal of your employment. Small pay cuts under that percentage, you might have a more difficult time treating that as a dismissal. You might be successful, but again, you might have a more difficult time in that regard. But certainly percentages like 15, 20%, if your employer just says, we're going through a difficult time now, we're in a recession, I need to reduce your pay by 20%, you don't have to accept that, and you shouldn't accept that. Now, you speak about, Aaron, this notion of making changes, and you've accepted them, and now they're continuing to make changes, your employer. And what all of you should know is that you can't accept changes and then at a later date decide that you don't want to accept them any longer. You have to act right away. And the reason why is because your employer will just defend themselves when you do act. And they'll say, but you've accepted the changes before. I did this last year, or I did this 3 months ago. So you can't accept it then and now come in and say, I no longer accept these changes to my employment. So you have to act right away. You have to take a consistent approach. Otherwise, your employer might well have a valid argument to defend themselves in that regard. So this is all to say, make sure that if these changes are happening to your employment, don't just wait to see what happens. Make sure you contact us. Make sure that you get advice from us about your specific situation, and we'll let you know whether these are fundamental changes and whether you should or shouldn't accept them. So Aaron, I hope that answers your question. And if you have a follow-up, again, feel free to post it in the chat. We have another question on YouTube from Love Deep. And he says, I signed a 1-year contract as an independent contractor, but discovered that it will not count as valid work experience as I am an immigrant temporary worker. My employer threatens to take you to court. And then Love Deep goes on to say, I've given them a 1-month notice already, but my contract mentions $2,000 penalty. I want to move out of contract with paying penalties as I just started, and it would be very tough for me to pay. Okay, so there's a lot happening there. What I recommend is that you contact us. We need to figure out exactly what's going on here, and we'll be able to answer your question more substantively. What I will say, though, is that if you are an independent contractor, you are technically, according to the law, according to your employer, I should say, you're different than an employee. And so this is a good opportunity to discuss that difference, an independent contractor versus an employee. And it's very common for employers to, again, I just dealt with this last week. It's very common for an employer to classify a worker, we'll call them a worker in this case, as an independent contractor, so that they avoid having to pay the normal entitlements that an employee is entitled to. And those entitlements include termination entitlements if that person is terminated. And what you should know is that if you sign an agreement that says you're an independent contractor, that doesn't necessarily mean you are one. You might sign something that very clearly says I am an independent contractor. I agree to that. But what the law actually does is it looks at the specific situation of this person and says, is this really an employee-employer relationship, or is it a relationship between an independent contractor and an employer? And if the relationship looks very much like an employee relationship, then you would be treated as an employee and you'd be owed your termination entitlements. You could be owed back pay for vacation pay, for overtime pay, etc. So that's a very important issue. Again, this is very common. Employers do this because they don't want to have to pay these entitlements. So be cautioned if you get an agreement that says that you are going to be an independent contractor agreement. It's ideal that you don't sign that from the get-go, but know that even if you have signed that, if you operate essentially as an employee, then the law will consider you an employee. And what does an employee look like? Well, if you work 40 plus hours for this employer, if you have an email address with the employer, if you have a workstation at the office, if the employer provides you with tools and equipment and helpers to do your work, if you are financially dependent on this employer, you might work for them exclusively. And even if you don't, all of those factors would indicate that you are an employee, not an independent contractor, regardless of what the contract that you signed says. So, Lovedeep, I understand that might have not specifically answered every part of your question, but hopefully that information was helpful to you. And like I said, if you have follow-ups, post it in the chat or arrange a meeting with us so that we can figure out exactly what's going on in your situation. And again, contact us at help@employmentlawyer.ca. Okay. Another update from me. So Lovedeep, you said, where can I contact? At help@employmentlawyer.ca. Okay. Well, let's squeeze in another question before we finish here. So a question from Julia. I was just let go from my position because my employer claims I stole from the company, but this wasn't true. I'm worried about my record of employment and being able to get a new job. Is there anything I can do? Absolutely. If you're being accused of stealing, and certainly if it's not true, then your employer probably in that case has terminated you for cause. And that means that they likely have not offered you any severance pay upon termination. Do not accept that. If you are being offered something, Julia, but your employer wants you to sign the dotted line to say, I accept this amount and you have no further liability to me, don't sign that dotted line. Usually it's called a release form. Don't sign that because you're probably owed much more severance than you're being offered. And if you were offered nothing, you probably are owed much more than nothing. So if you are being let go for any reason and not being paid severance pay, and especially if the reason that your employer is claiming, in this case stealing, is not true, then make sure that you contact us because you're certainly entitled to your severance pay in that case. And again, it could be as much as 24 months. And with respect to your record of employment, we could also help you with that. We can potentially get your employer to issue a record of employment that does not indicate that you were terminated for cause, but rather that you were terminated without cause, in which case you should be able to get EI, first of all, employment insurance in that situation. And it will also help you get a new job as well. So that's it for me today. It's been great to be here. We had a lot of excellent questions on a variety of topics. There's a lot going on now in the world of employment law. And so I'm happy to see the questions rolling in. And we will be back. We have another session at 1:30 p.m. On November 28th, this Monday, with my colleague Chris Justice. So make sure you tune in live for that. And we have another session as well on Tuesday, November 29th, as you see on the screen, for a disability law Q&A with my colleague Darren. So make sure you tune in for that as well. And have an excellent day and a great weekend. Take care.